with Bajam Shah Immigration Law Group for another immigration webinar. So we are going to be talking about EB-1, the multinational manager and executive filing for I-140. Bajam Shah is a boutique immigration law firm, and we have been handling exclusively corporate and family immigration law for the past 25 years. Today, I have with me Murali Basham, our managing partner, and business immigration paralegal, Emily Gray. Thank you guys for joining today.
How are you?
Hey, how are you?
Yeah, so we're going to talk about the EB-1 multinational manager and executive filing. You know, I just said that, but so what exactly is that filing? I know it relates to I-140, and some people have a lot of questions about it, but just kind of to start from the beginning, what is this classification in this preference category?
Well, it's a green card category under the employment-based preference 1, for executives and managers. And I know we do a lot of them, Emily does. So maybe Emily wants to go into a little bit of a short description of the category itself.
Yeah, sure. So the EB-1 category is for those people who were in a managerial position at a foreign entity. So this managerial position,
or executive as well, yeah.
Yeah, so a manager or executive. So they have to either manage professional people or kind of an essential function of the company itself. So they have to be employed for at least 1 year within the 3 years that they entered the United States, or within 3 years of when they're going to enter the US on this EB-1 category. And the company, the foreign entity, has to be somehow related to the US entity in which they're transferring to, either a parent, subsidiary, or affiliate company. And at the US entity, they also have to be in a manager or executive position, the same type of criteria as they would have to be managing either a department, people, or an essential function of the company itself.
Okay, so laying that basis down, Murali, what are the qualifications for EB-1? Emily was kind of getting into it. You have to be in a manager, managing an essential function, but kind of going more into it, what are the qualifications?
I mean, the qualifications, she basically hit on it, which is 1 year of employment abroad, with the parent, subsidiary, or affiliate company. But I think from a qualification standpoint, the thing that comes up the most is what is an executive and what is a manager, and we've seen that a lot, with the cases, especially over the last few years, because those definitions have changed with USCIS and they become more strict. Sometimes a CEO doesn't qualify as an executive according to the USCIS anymore, which is kind of ridiculous, And so from a definition standpoint, if you meet the 1 year, if the companies are related in the right way, and the person is going to come to the US to perform in an executive or managerial role, as Emily said, then we need to dig into what does the USCIS consider to be an executive or manager, and I'll give you my 40,000 foot definition of this because I know we are short on time, but an executive is someone who basically manages the managers, the senior level managers who, decides what the goals of the organization are going to be, what the direction of the organization is going to be, and maps out the future of the organization. And then the senior level managers, your VPs, et cetera, then they carry out that vision of the CEO. So that's the general definition of it. Now, who is a manager? A manager is someone who actually manages professional workers, and professional workers means, people who are actually, in a role that requires at least a bachelor's degree in a professional field, and so it's very important for us and every immigration law firm to really dig into those details and get that information from companies to make sure that in that organizational chart, you're seeing this manager be at a very senior level role, and so that's really what we have to prove. That's really the hardest part. I mean, it's easier to prove the 1 year because you can do that through pay stubs and everything else. It's easier to prove the parent subsidiary affiliate relationship. You do that through corporate documentation, but the USCIS really wants to see the definition of a manager and executive being proven by the company and by the attorneys. And I say this, and Emily, you know this, handling a lot of cases, just because someone gets approved for an L1A, which is the non-immigrant version of this, the work permit version of this, does not necessarily mean that they qualify under the EB-1 executive manager category, because the USCIS basically adjudicates those cases to a much higher level than an L1A, So these are the things I think everyone needs to keep in mind when they're looking at doing a case like this.
So compared to, say, the H-1B that we handle a lot of, the EB-1 category in the filing is held to a higher standard of scrutiny than an H-1B?
I think every green card case, ultimately is held to a higher standard of scrutiny than any, non-immigrant work visa case, whether it's L1A, L1B, H-1B, it doesn't matter. Even though I'm not saying those aren't held to a higher standard, they are a high standard anyway, but green card cases, the USCIS looks at it a very different way, which is, if we're going to grant you a green card, we want to make sure, you really rise to that level to where, I guess this is the wrong way of saying it, but you're worthy of it,
Mm-hmm.
So you mentioned the L1A is typically the prerequisite for the EB-1 filing, but say if someone is on L1B or H-1B, could they still qualify for an EB-1 filing?
Well, it depends. Let's say someone's on an L1B, their specialized knowledge, which is, for the folks who don't know, that's what L1B is for. Let's say they were specialized knowledge at the foreign company for 1 year, got transferred to the US, working in L1B status, and status changes to L1A once they get promoted to a manager. Or they're specialized knowledge outside the US for 1 year, and then they're going to be a manager in the US, so the US company gets an L1A for them. And this is a question we get a lot as well. Just because you're a manager in the US in L1A status does not automatically mean you're qualified for the EB-1 category, because the EB-1 category is simply for someone who's an executive or manager outside the US for a year, and who's going to be an executive or manager inside the US for a year. So going from specialized knowledge for a year outside the US to manager in the US does not qualify someone for an EB-1 category under this particular category. Now, going to your H-1B question, let's say that someone was a manager or executive for 1 year outside the US, with the parent subsidiary affiliate of a US company, and then the US company does an H-1B for them, and brings them in on an H-1B, are they qualified under the EB-1C category if they're a manager in the US or an executive? Absolutely, from a legal standpoint. So just being on an H-1B does not preclude you, from qualifying under this category, but having specialized knowledge outside the US and then coming in as a manager would preclude you from qualifying under the EB-1C. But just note one thing, people who are managers also have specialized knowledge, so you have to really look into that at the foreign company and the employment that occurs at the foreign company, dig into that to see exactly what that person was doing.
If they were a manager, but they also had specialized knowledge. Okay.
Okay. Yeah.
So, I think about 2 weeks ago or a little bit longer, we had discussed PERM. So, Emily, for the EB-1 filing, is a labor certification or PERM required?
No, it's not required. And that's why a lot of people who do believe or are under that L1A really prefer to go under that EB-1, just because it's a little more, if they do qualify and have a strong case, it's a much more straightforward process, and they don't have to worry about, having a US qualified worker with that PERM process. So no, a labor certification is not required.
Is it a faster process though? We get a lot of questions about whether, the EB-1, people want to get into the EB-1C category a lot because they think it's faster. So is it,
That's a good question. Well, we can go over the processing times. So for the EB-1, I-140, unfortunately, premium processing is not an option. So when you do get to the process or filing of the I-140, you have to go under regular processing. Right now, with USAS, the I-140s are taking anywhere between 8 to 10.5 months to be adjudicated by USAS. One of the benefits of being an EB-1, if you aren't necessarily an Indian or China national, is that you would most likely, depending on the visa bulletin, be able to concurrently file your I-140 along with your adjustment of status. And another, looking at the visa bulletin now, the category for the EB-1 India is, the priority date is March 2018, whereas in the EB-1 and EB-2 categories, they're still in 2009. So that's a 9-year difference of waiting times for them to be able to file their adjustment. So it could be faster, and it could not be faster. So it really just depends on kind of how the visa bulletin moves, and then the processing of USCIS at the adjudication stage.
With the visa bulletin piece though, like for example, Indians and Chinese have the backlog, back to March 2018. The other nationalities don't have that backlog. So a lot of the nationalities can actually concurrently file the I-140 and 45.
Yeah.
But if you're an Indian or a Chinese national, you can't, simply because of that visa bulletin backlog.
Mm-hmm.
Now, you can in some situations because, we do have, clients who have had EB-2 cases filed for them who have approved I-140s, who would also qualify under the EB-1, based on the circumstances and the facts. And those folks, let's say that I-140 priority date is before, or it meets the visa bulletin now, they could port that priority date to the EB-1 case, and then if it works, then concurrently file the I-140 and 45, and we do a lot of those cases as well. And I think it's important as a strategy to look at everything, but just from a processing standpoint, it's a great category for all nationalities. For Indians and Chinese, then it's going to be a little bit of a backlog here, based on what we're seeing, but it is starting to speed up on the visa bulletin from what we've seen a lot, so it's certainly something that's worth pursuing if you qualify for it.
Yeah, of course. So kind of thinking about that then, so if someone comes over on, say, L1B, and they're in L1B for 2 years, and then their company tries to have them, maybe they don't qualify for L1A, and they try to get into the H1B lottery, and maybe they're just one of those unfortunate souls who 3 years over don't get picked in the H1B lottery. So they can't apply for L1A, they have run out of L1B, and they can't qualify for H1B. So they have to return to their home country, but they're still gonna work for the company. Could they file at that point for their EB-1 outside of the US?
So what they have to do first, and again, we see a lot of employees who do actually go back for various reasons to qualify under the EB-1C category, but what they'd have to do is go back for a parent, subsidiary, or affiliate and work for 1 year first in an executive or managerial capacity. And after that 1 year, the company can file the EB-1C green card for them, even if they're still outside the US. Or they could also do the L1A at that point, and bring them into the US and then file the EB-1C green card for them. There are various strategies to this that companies and employees do, and have been doing for a while, simply because there is a benefit to that EB-1C, as Emily had pointed out, from a processing standpoint.
So then kind of on those options, if someone does come back there, so the company holds off on filing the L1 or EB-1, and the person comes back on L1A, is there a certain amount of time they have to work on L1A before the company can file for that EB-1?
No, there isn't. Basically, the company could file immediately, whenever they want, as long as they meet the simple items that companies have to prove that Emily went over in the very beginning. The 1 year of employment, the parent, subsidiary, affiliate, branch office relationship, manager, executive, that's all they have to prove. Once they meet that, then they can go ahead and file the case.
So then if the EB-1 is approved, so they have that approved I-140, I know that a lot of people, it applies to H-1B. If you have an approved I-140, you can continue to extend your H-1B. Is that the same for an L1? They wouldn't be able to, even if they had the approved I-140?
Emily?
No, for the L1s, you have, if you're on L1A, you have that 7-year max. For that L1B, you have that 5-year time limit. Okay.
So if the person is not able to get, so just kind of like thinking about it from a strategy wise, if, it's kind of getting to maybe their 7-year max, they would, but they have the approved I-140, they and their company would need to strategize whether to try to get picked in the H-1B lottery or whether to go back to the home country and work for the company there for a year to then try again, after a year of working abroad.
I'll give you a fact example here.
Okay.
Let's say that someone was a manager outside the U.S., came to a parent subsidiary affiliate company, is a manager in the U.S., and then they get the I-140 approved, but they're still in L-1A status, and they've been on L-1A status for, let's say, 4 years, and let's say the priority dates are backed up, and they need to have the I-140 to extend their status past the max on their L1. A lot of companies then would try to file them, an H-1B for them, under the lottery, because once they get that H-1B status, then you can use that approved I-140 to extend their H-1B status past the 6-year max on H-1B until they're able to get their priority date current, and be able to file the I-485. So that's a strategy that we've used, as all of you know, and that companies have used. And I think it's important for companies and attorneys and employees to kind of keep that in mind from a timing standpoint as well, because H-1B is a 6-year max. Any time spent on L1 is counted towards that 6 years on H1. And people tend to forget that sometimes, so timing matters in all of this.
Yeah. So definitely thinking about it ahead of time before.
Think about it ahead of time. Correct.
Yeah, I was gonna say definitely a legal strategy.
Yep.
So with EB-1, so say that they get EB-1 approved I-140. So maybe they haven't got yet to the I-485 stage. What if there's a significant change in duties at the EB-1 stage? The EB-1's approved, but there's been a significant change in duties. Kind of what's going to happen?
It depends what that significant change is, really. I mean, is a manager going to become a non-manager? I mean, that's really. I guess that's possible, but if that happens, that's a significant downward, really, change, right? And that would impact a person's not only L1A status, but impact the EB-1C approved I-140 as well, because the person would no longer qualify as a manager, And but let's say that I'm on L1A, have an approved EB-1C I-140 as a VP of something, Yeah. I actually like that title, VP of something. We should make that. All right. So VP of something, and let's say that I become the VP of something else, then that change from VP of something to VP of something else really shouldn't change the case, because if I'm still managing professional workers, who have degrees, and I'm in that hierarchy where I'm reporting at a very senior level, as a manager, then those types of changes wouldn't have an impact on the L1A or the EB-1C approved I-140.
So would your answer change if the I-485 and the I-485J had been submitted already with what was filed on the EB-1?
Yeah, this question has come up multiple times, and I don't think there's a very clear answer to any of this, honestly, but no, it would not for me. I don't think for us that would change. We really have to look at what's the nature of the change, how different are the duties, to where does it really go into a completely different role that we feel the USCIS has to adjudicate, or is it just a simple minor change that we think really it doesn't really change what they were doing before, other than maybe adding to it a little bit, So these are the decisions that we as attorneys and paralegals have to make, right? And I think every law firm, every company has to look at it that way.
So ultimately, always talk to your attorney if you think that there's going to be a change in your job duties.
Always talk to the attorney in the paralegal case, yes.
They are well aware. Okay, well, that has really, I think, covered a good basis of what the EB-1C category is. Emily and Murali, is there anything else you would like to say about EB-1C or about immigration in general right now?
Emily, I'll let you go first, and then I'll add a few things.
No, I just think that, the most important thing is making sure that you have the documentation to prove your, managerial or executive status. One thing to keep in mind are, how are you managing these people? Are you doing performance reviews? Are you, giving them vacation? Are you giving them raises? To always keep records of that, because those will certainly help your case and make them stronger. So just keep in mind different items, when you're preparing the case that could be used for your case, and just keep them handy.
Yeah, I know we have to get innovative sometime, but ultimately the EB-1 is a very document heavy application because we have to prove that the person is managing an essential function of the company, which is its own thing, but also that they're managing people, which can be also a different aspect of it. So I do know that too.
Yeah, you both are right. They're very document heavy. The cases we file are like, couple of questions I've been getting, recently. Number one, just because you're a manager in the U.S. doesn't mean you're qualified for the EB-1C. I get a lot of those questions where, people get promoted in the U.S. to a manager, but they're on an H-1 and they've never worked for the foreign company or anything else. And they're like, well, can I qualify for EB-1C? And the answer is no. You have to meet the standards that we discussed during this Facebook Live. Contact us, obviously, if you think you might meet it. We're more than happy to tell you whether you do or not. The other thing is the definition of manager executive. If we ask, an employee or a company to please provide all of these lists of documents and information to prove that the person is a manager, the incorrect answer to that would be because they are. So as Hayley pointed out, and Emily, I mean, we need a lot of information. It's not because we need it. We need it to prove it for you, for USCIS, so it might seem burdensome, but it's just what is needed in this immigration environment, which is a very tough immigration environment. Having done this for 25 years, I've seen L1As and I-140s for EB-1Cs processed over time. It's very different now. Over the last 4 years, the standard is much, much higher on proving, how you really meet that managerial standard. You just have to look at it as the immigration service wants to deny the case before you even file it. So we have to prove that otherwise, right? And so the more documentation and information we provide, the better it is. And I think from a long-term strategy standpoint, if you do work for a multinational company, a very global company, and the company has flexibility on transferring you back outside the US, and working in a managerial position for 1 year, we've seen clients do that because they have flexibility from a personal standpoint. The company has flexibility from a professional standpoint, et cetera. But just remember one thing, laws don't always exist today as they will exist in 1 year, so you're taking a risk, and things might be different a year or two from now, so just understand that risk. And we always advise our clients to understand that risk before they make any move like this. But overall, it's a great category, if you meet the requirements for it. And just as Hayley and Emily have pointed out, just make sure to discuss it closely with your immigration attorney and your company.
Yeah, awesome. Well, thank you both so much. So again, this is Basham Shah Immigration Law Group. You can find us on pretty much any social media platform as @Basham Shah. Our website is bashamshah.com. You can subscribe to our newsletter. We send it out every Monday at noon for the most up-to-date curated immigration information.
Thank you, Hayley, for being such a great moderator today.
Yeah, thank you.
Thank you guys. Bye.
Thanks, Emily.